If you have a restraining order hearing coming up and you are planning to represent yourself, or even if you're not and you're hiring an attorney, make sure that you watch this video because I'm going to be addressing a recent phenomenon where judges are basically going rogue and restructuring how they handle these restraining order hearings due to jam-packed calendars. And so if you are doing your own research on here on YouTube, trying to figure out what to expect from this hearing, how you should prepare, maybe you've taken a course like the one that I teach on this. Sometimes judges do not follow the law. I want to make sure that you are absolutely prepared for anything that can happen when you show up for your restraining order hearing. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything that you need to know to represent yourself at your restraining order hearing and win. I teach you how to ask the other side questions, how to object and keep their evidence out, how to present your own evidence, all of that. And again, in this video, I'm going to be explaining basically what to do when the judge goes rogue. And I'll explain exactly what I mean by the judge going rogue. Okay, so let's jump right in. So typically how a restraining order hearing will go is that the petitioner presents his or her evidence. The respondent gets to ask the petitioner questions. It's called cross-examination, sort of poke holes in their story, bring in proof that what they're saying isn't true, and also while the petitioner is presenting their story, the respondent can object. For example, if the petitioner just tries to play a video without explaining what the video is, when it was taken, then the respondent could object based on foundation. Or maybe the video contains somebody other than the respondent saying something, like the petitioner saying something. Okay, well then you can object based on hearsay. And many times with those objections, you're able to keep their evidence out altogether. After the respondent is done questioning the petitioner, now it is the respondent's turn to present his or her evidence. Then the petitioner can ask him or her questions, and then each side can generally give a short little closing argument if the judge allows. So that's the typical format, right? It's very similar to what you would see in a trial. But court dockets are slammed, and what will happen is that judges who are assigned a restraining order docket are given 20 or more cases that they're supposed to hear many times in a single morning, not even all day long, but just a single morning. How are they going to do that, right? So what a lot of them have started doing is, instead of having this sort of mini trial, they'll do is have the petitioner present their evidence, not allow any objections, not allow any questions, and then let the respondent present their evidence. And the judge themselves, many times, even if each party has an attorney, will not let the attorney ask questions. The judge instead will sometimes either ask questions or nobody asks questions. Is that legal? No, there is case law showing that that is not legal. And in fact, I got an email from someone who had taken my course and did find it helpful, did win the hearing, but said that this judge had refused to allow cross-examination. So I sent him a case showing him, here, the judge is required to do that. And you want to be prepared as possible. You want to be prepared for the longer form hearing, for sure. Especially if you can potentially keep all of their evidence out or poke holes in their testimony with questions. You definitely want to do that. But what you don't want to do, and thankfully he didn't do, is tell the judge, especially as a non-attorney, is tell the judge, Your Honor, what you're doing is illegal. I should be allowed to ask questions. Here's this case law. Because the judge may say, yes, you can ask questions, sure. But then the judge is going to have a bad taste in their mouth about you. And that is not what you want to do, because what happens if you lose one of these hearings, if the judge decides against you? Even if that's totally the wrong decision and the judge is biased, what are you going to do? You're going to file an appeal in the Court of Appeals that's going to take potentially years to get heard. And to go to the Court of Appeals, you kind of do need an attorney. So if you're in the position where you're representing yourself here, you don't want to then have to hire an attorney to go to an appellate court. And then even if you win, you probably just get to do the hearing all over again. Meanwhile, maybe you're kicked out of your house, sleeping in your car, can't see your kids. Plus, you might lose the appeal. There's no guarantee that you would win, even if the judge did do something wrong. So you really want to make sure that you get it right the first time. So let's say that you do end up in one of these situations with one of these judges who has gone rogue. And by the way, I mean no disrespect to them. What are they supposed to do? If they don't have time to get through all of their cases in a morning, they're going to have to push a bunch of cases to another day. But on that other day, now they're assigned 20 more cases, and it just stacks up to the point where it's impossible for them to get through it. That's why some of them are doing this out of sheer necessity. The other option is that these restraining orders, the temporary ones, remain in place potentially for years while we have this clogged docket. So what you want to do is go with it. Go with the flow. Go with what the judge wants to do. Don't piss off the judge. Now, I have had people who've taken my course or watched my videos, and when they object the first time, the judge seems a bit taken aback. But then if the judge says sustained, meaning they agree with you on the objection, and I have videos on the objection, they're also in the course, then you can keep going. And I've had people who told me that the judge was taken aback, but then the judge sustained their objection and they kept objecting, and the judge sided with them ultimately on the entire thing, kept sustaining their objections, and it was pretty much like saying magic words, and ultimately they won the hearing that way. But if you try once and the judge says, no, don't do that, or seems annoyed, not just overruled. Overruled means that the judge isn't agreeing with you on that objection, but you can still object in the future. But if the judge looks really pissed off that you're doing this, and especially if the judge is just having one side go and then the other and not letting any questions happen, then I would stop. I mean, you're going to have to read the judge. Hopefully you're not the very first one to go that morning. And if you're nervous about this and you have time, I would encourage you to actually go and watch the judge ahead of time for other people's hearings so you can see what you can expect in that courtroom. And by the way, you may also find out the judge will sometimes force people to go to mediation. So mediation is basically where you have a neutral third party, it's a lawyer generally volunteering, who will sit down with you, sit down with the other side, and try to see if they can come up with some sort of resolution. Now, a lot of people are like, no, I definitely don't want to do that, right? There's no way I'm conceding anything. I'm not doing mediation. What I would encourage you to do is if the judge offers mediation, volunteer to go. Even if you know that there's no way that you guys are going to come to some kind of agreement. You're maybe total enemies at this point, right? You've been falsely accused, or the other side was the abuser if you're the petitioner, and you're just like, no way. You know what it shows the judge when you volunteer to go to mediation, because most people don't want to go? It shows that you're reasonable. It shows that you're a team player. You will get some favoritism from the judge if you volunteer to go to mediation. And if you say, yes, Your Honor, I'm willing to go, and the other side says, no, I'm not going, then they already look bad. You've already won some points for free. And all you have to do, it can be very quick, is sit with the mediator and see if there's some sort of issues that you guys can work out outside of court. That's basically all that it is. And hey, maybe you'll be able to do that. But a lot of times when somebody has filed a restraining order, especially domestic violence restraining order, and it's a lie, or they're trying to take your kids away, or, you know, they've kicked you out of your house, understandably, you might not want to do that. So the judge has gone rogue. Your hearing is going to start. What should you do, like, step by step? What you want to do is present your own testimony and your own exhibits. So you'll just tell the judge in a narrative format. Narrative meaning you just tell your story, your side of it. Now, if you're the respondent, you will have just heard the petitioner telling their side of the story. So what you're going to want to do is address their allegations. And the judge may give you some guidance. The judge may say, go in reverse chronological order, meaning start with the most recent stuff and go back. If the judge says that, then do that. Otherwise, I would probably go in about the same order that the petitioner went in, so that it's very clear for the judge what you're addressing. So I'd like to address the first issue that the petitioner brought up, that whatever act of abuse it is. Okay, second issue, third issue, fourth issue. And then I would even end with, I think that's everything, Your Honor. And then that gives the judge a chance to say, well, you didn't bring up this other thing. You missed, something that they brought up. So that way you make sure that there are no loose ends. Now, as you're going through in chronological order, if you have any evidence, then show your evidence. And even if it's in this sort of informal format, what I would make sure to do is bring at least 3 copies of each document. That way you have a copy, you can give a copy to the judge, and you can give a copy to the other party. So everybody has one, because otherwise, if a judge is doing it this way, they're doing it to save time. Otherwise, you're wasting a lot of time with everyone trying to look at one single copy of a document. And a big thing that you're always going to be asked by the clerk, by the deputy, by the judge is, has the other side seen your documents that morning at court? And you can ask the deputy if they can hand it to the other side. They're going to be impressed by that, because what happens is a lot of people get up there and they are trying to present documents, but they haven't shown them to the other side. And then what happens is that the proceeding basically has to pause while the other side looks at it. What if it's extensive? What if it's a month's worth of text messages? It's going to take forever. No one wants that. So that's why you'll be asked a lot of times if you've shown the documents to the other party. And by the way, make sure that you're not trying to show anything on your phone. There are some courts that will allow it, especially for restraining orders, but I would call the court first and ask them how you can show your documents. Many courtrooms will allow you to email them in advance. Some of them will say, bring a laptop and bring an HDMI cable. Some will say bring a laptop and the judge will just look at your laptop. But it's worth finding out ahead of time. That way you can show your evidence and you don't get into a situation where the judge says, you know what, you're not ready for this hearing. We're just going to continue it to another day, because many of the hearings are going to get continued to another day. And if you want your case to be heard promptly, especially if you are suffering with a TRO in place, then you want to make sure that you don't give any reason for the judge to say, you're not ready, get out of here. Plus, you really want to be as prepared as possible in order to put your best face forward in front of the judge, because the thing is, the judge has to decide very, very quickly which side they're going to go with. And the standard for domestic violence restraining orders is slightly over 50%. So if they believe the petitioner's story more than the respondent, slightly more than 50%, then they choose. So they're choosing really quickly. They don't typically think about this overnight. They're not deliberating. They're deciding during the hearing, maybe during the first minute of the hearing, which side they're going to go with. Maybe they're deciding when you raised your hand and said, I want to go to mediation, I'm willing to go to mediation. They might have decided right then, because they have so many to get through. These cases are not typically appealed or looked at that closely. They just have to make a decision and do it fast. I hope that you found this information helpful. And if you are planning to represent yourself at a restraining order hearing, I do have a free first class in my course you can check out. Go to defeatthedvro.com, and you can also click on the link in the description box if you'd like to go there. And if you did find it helpful, please don't forget to like, subscribe, and ring the bell.